Hi, everyone. We are here today to discuss the cross hearing that took place earlier this morning. I am Akilah Deernose, Executive Director of the ACLU of Montana, and I have here with me.
Hi, I'm Malita Picasso. I'm a staff attorney at the National ACLU LGBTQ and HIV Project. I use she, her pronouns, and I'm one of the attorneys on the cross file.
And I'm Alex Reed, Deputy Director and Legal Director for ACLU Montana, he, him, and I carry Malita's bags for her.
Just start by asking you for people who are listening who may not be following the case, can you give us a little background on what the cross case is about?
So in 2023, the Montana legislature passed a SB 99, a law that effectively prohibits providers from providing gender affirming care to anyone under the age of 18. And we being the ACLU of Montana, the National ACLU, as well as our co-counsel, Lambda Legal and Perkins Coie, brought a challenge under the Montana state constitution against the bill on behalf of both providers of gender affirming medical care and also patients, so adolescents who are receiving gender affirming care and their families and their parents. And so our challenges have really focused on the right to privacy under the Montana state constitution, which is a very expansive right to privacy as compared to the federal right to privacy or other states. We also brought a claim under the Montana Equal Protection Clause, essentially saying that the SB 99 discriminates on the basis of both sex and on the basis of transgender status, and that is a violation of Montana's Equal Protection Guarantee. We also brought a claim on behalf of the parents of transgender minors, a fundamental parental rights claim, essentially saying that it infringes on their ability to make decisions about the medical care that their children receive. And we also brought a speech claim against some of the provisions that limit or prohibit the use of state funding to advocate for the provision of gender affirming care for minors. That is a lot. So there's a lot of things going on there, but essentially we wanted to take advantage of some of the really great case law that has been developed over these years in the state of Montana, because this is just a clear infringement and a clear overstepping of the legislature into people's lives and people's private medical decisions in a way that is incredibly harmful and contrary to fundamental understandings about how medicine should be practiced and science, and is very obviously being motivated by animus towards trans people, and sort of piggybacking off of the nationwide animosity and targeting of trans people that we're witnessing right now.
Yeah, I mean, just picking up off that last point. So SB 99 in 2023 was one of multiple bills that were intended to marginalize and target transgender Montanans for differential treatment. We saw laws that purported to define sex in the binary based on reproductive capability, essentially sort of this wholesale effort to erase trans, non-binary, and intersex people from public life in Montana. And that has, of course, continued into 2025 with the adoption of a bathroom ban and some other bigoted measures that the legislature has debated. A couple of other sort of pieces of this puzzle. So one, the case that we filed, Cross v. State, was filed on behalf of an amazing group of clients, plaintiffs who included two of the primary providers of gender affirming care in the state of Montana, a few different families, each of whom is on their own journey as it relates to their trans adolescent who is receiving gender affirming care. And right out of the gate, we were able to obtain what's called a preliminary injunction, which is a order from the court essentially putting the law on ice while the litigation is pending. So the good news is that over the course of the last few years, since SB 99 was implemented or enacted, it has not been enforced as a result of the successful lawsuit that we brought on behalf of our clients.
And so you were in court this morning. Can you tell us why you were in court this morning and what that means for the case?
Sure.
Or what it could mean
Yeah.
to the case?
I'm happy to go. Okay. So, part of litigation has many stages, and it often takes many years. And so, over these last few years, anybody who's been following the challenges to bans on gender affirming care across the nation have probably been hearing the words injunction or preliminary injunction, which Alex just explained. But that's not the end of the case. That is just the beginning. And where we are now is a trial was set to take place in June. And but before you get to trial, parties can do what's called move for summary judgment. And essentially what we're saying is, judge, if you look at all of the evidence that both parties have presented so far, if you look at the record, if you look at everything right now, we are entitled to win as a matter of law, and we don't even actually need to go to trial because based on undisputed facts, we win. So plaintiffs who we represent and the state of Montana, or the defendants in this case, both moved for summary judgment. And so today's hearing was to actually hear arguments on both of those motions. And what it would mean if it is granted, if plaintiff's motion for summary judgment is granted, is essentially it would be resulting in a permanent injunction against SB 99, and the trial would essentially be canceled. But that is not really the end of the story either. Oftentimes, after a motion for summary judgment is granted, there are appeals that go up. So this isn't certainly not the end of the road, no matter what happens after this hearing. But we are very hopeful that it's just very clear based on this record that we are entitled to win under existing Montana case law, because specifically, I think really what we've been focusing on a lot is this idea that SB 99 is just way too over-encompassing. So the state of Montana has tried to justify SB 99 by essentially saying that gender affirming care needs to be banned because it is harmful, or because it's too risky, or we don't know enough about this care. But when you really look at the record, you see that they're proposing that they're claiming that there are problems where really none exist. All of the major medical organizations in the United States support the provision of gender affirming medical care to adolescents. There are very clear standards of care in how you provide this care, and there isn't really a dispute as to the effectiveness of this care to treat gender dysphoria in minors. And so even if any of the concerns that the states, is suggesting that they have about access to gender affirming care, their decision to just completely ban this care, as opposed to trying to address any of those specific risks, is really in and of itself clear proof that the legislature has overstepped its authority and entered into the private, medical decision-making sector. So I think that's going to be that was a big focus in today's hearing, is the fact that a total ban is just so out of line for any of the risks that they are purporting are posed by gender affirming care. And I think also it was clear that many of the risks are very disingenuous, in the sense that there's risks associated with pretty much every type of medical care that anybody receives, and there's strong protections for people in Montana, including minors, to access care that has a much lower level of evidentiary support about its effectiveness. And so really the question is, why is this care being singled out as compared to any other type of care that is not only being provided in Montana to minors, but is actually protected by Montana law from the government trying to take away their access to them. So I think that those were some of the big sort of topics that were that Alex focused on during the hearing today. And I may have missed.
And you said that if the judge ruled in favor of plaintiffs today on the summary judgment motion, that would mean that the case would be permanently enjoined. Can you explain what that means?
Yes. So a permanent injunction. So when we filed this lawsuit back in 2023, you know, in your original complaint, the sort of document that you file with the court where you say this is what we're saying, this is violating the law. This is, you know, our arguments. You have to request a certain type of relief. And what we requested, among other things, was a permanent injunction where we're saying the state of Montana should not be allowed to enforce any aspect of this law because it violates the provisions of the Montana Constitution that I mentioned at the beginning. So a permanent injunction would basically, it's just to distinguish between a preliminary injunction, which Alex was describing, which is only enforced during the litigation itself. It's essentially preventing the state from being able to enforce the law while the case is ongoing, whereas a permanent injunction would mean a final ruling on the merits where the court would recognize that this law violated the Montana Constitution and that the state is not permitted to enforce any aspect of it. Gone.
Activity.
I mean, I would say that was about the most comprehensive overview.
I mean, the only other thing that we have is just in terms of what we're seeking is, and we do this in almost all of our cases when we're challenging a statute or a rule that we think is unconstitutional, is a permanent injunction, joining it from ever being enforced, but also a declaration that it's unconstitutional. So what we're asking the court to do is to declare with finality that SB 99 violates our right to privacy, protection, right to parent, etc. And the hope, although this has not been borne out historically, is that if the courts say, look, this law is garbage because it violates the Constitution, then potentially in the future, the legislature might not enact another law that patently infringes upon people's constitutional rights. And unfortunately, the legislature has not gotten the message, but we hope that if we just keep banging that drum, that eventually it will resonate with them and we won't have to constantly be dealing with bigotry and hatred, not just against the trans community in Montana, but also on issues like voting rights or issues like Indigenous justice. Those are all important for us to sort of lay out the guideposts of the Montana Constitution so that people are dissuaded from doing bad things in the future.
And so relatedly, if you did get the declaration of that law was unconstitutional and it was begun permanently enjoined, how would that impact other pending lawsuits that you have related to similar issues of transgender rights?
So we have a whole bunch of cases in the trans rights context involving identity documents, involving a new bathroom ban, involving definitions of sex, involving LGBT inclusive curricula in public schools. And if we're building sort of a body of law in Montana that essentially says that it is a violation of the Equal Protection Clause to single out trans people for differential treatment. And so the more decisions we get from these courts, the more helpful that's going to be in all contexts. But I think Malita alluded to this earlier, like the ball game is at the Montana Supreme Court, because it's one thing for a single district court judge to say that this is what the law is. Ultimately, all of our cases
whether they're trans rights cases or not, end up at the Montana Supreme Court. And that's where we really need the court to weigh in definitively, because they're the ultimate interpreters and arbiters of the Montana Constitution. So this case has gone up preliminarily, but it will no doubt be going up with finality, regardless of which side prevails at the district court level. And so that's going to be, the final determination from the Montana Supreme Court is still TBD.
Before we open it up, questions, is there anything else that you would just like to impress on audience about these cases and what to be paying attention to?
Yeah, it's interesting because when you were asking about the impact of, receiving a declaratory judgment in our favor or obtaining the permanent injunction that we're seeking, the first thing that came to mind is just the impact that it's going to have on the trans community in Montana, the impact that it's going to have on their families, and the impact that it's going to have on the providers of this care. So, when we're talking about these cases, sometimes what gets lost is the very real human impact, the ways and the severe consequences and damage that laws like this have in people's lives. Since the law was enacted, since before it was even enacted, Montanans were having to seriously consider where they were going to receive their medication. People were considering having to flee the state. People were considering any options that they have for those who have them available. And it's devastating. Talking to Montanans, it's truly terrifying, the idea of having the government come in and tell you, for example, as a parent, that this medical care that you've seen improve the quality of your child's life is going to be taken away from them. Or being an adolescent who is already navigating all of the difficult challenges that being an adolescent, entail, being in high school, everything, and being trans, and then on top of that, having to just fight for your basic right to access medical care is just, it's horrifying. And then the providers are, themselves being targeted and lamented in public and by society about providing this care that has literally saved people's lives. And so I think getting this permanent injunction, even though, it's definitely going to involve going all the way up to the Montana Supreme Court, it's these wins send a clear message to Montanans, to trans Montanans and their supporters, that you deserve to be here, and the government does not get to tell you that you don't get to exist in your state.
Yeah, I would like to that's a perfect mic drop end. There is one other aspect that I just want to add, which is that y'all are going to be hearing a lot about trans healthcare over probably in June, when the U.S. Supreme Court hands down its decision in the federal case called Skirmetti. And so that's going to be all over the news. And with what we know about the composition of the U.S. Supreme Court, the likelihood is that that decision is not going to be great. So what folks here in Montana need to remember is that the federal constitution sets the floor of our rights. The state constitution can set a higher floor. And that's what we're trying to do in Montana, is to make sure that there is a higher floor in terms of the protections that exist. And a good example of that would be in the abortion context, where with the Dobbs decision that overturned Roe v. Wade, it sort of kicked the issue of abortion regulation back to the states. And in states like Montana, abortion remains legal because we have a robust and vital constitution. Whereas if you go to North Dakota or if you go to Idaho, it's a very different legal regime. So keep all of this stuff in mind when you start hearing more about what's happening on the federal side come June, that what we're trying to now do is ensure that in places like Montana, the right to access life-saving gender-affirming care remains legal.
And now I will open it up for questions, if there are any in person or in the chat.
I'm actually from Idaho, and they passed House Bill 71 and 93, and 5 minors committed suicide that year. After. So what do you do in the aftermath? Is there any like legal recourse in the aftermath? Because they've shut down, I think there's only 2 gender affirming care centers in Southeast Idaho now. And so I guess I'm just kind of wondering what you do after.
After a
It is
law is passed and upheld banning transgender healthcare use.
I mean, unfortunately, that is the reality for many people right now, especially in states that don't have as robust privacy protections or constitutional protections as Montana. Is the reality is many people are having to flee states or seek care elsewhere. What's particularly disturbing about some of these laws, though, that are passing, many of them are trying to, make efforts to extend their reach beyond even their own state borders for people who are seeking care out of state. At this moment, I can't recall if that is true of the Idaho law, but I do know that it is true of many of the laws that are being passed. And so it's disturbing. And I think this is a weird thing for a lawyer to say, but like in many ways, also the law is not going to be the end of like saving us. And I think especially in times like this when there's so much fear and anxiety and relentless attacks, I think it's more important than ever that we try to build support and community with one another and help figure out, how we are going to get through this. Because the truth is, we are going to get through this. And we as a community have been through so much historically. And what we're seeing right now is a return to the way things were for decades before, where, the reality is many people are going to be seeking care, not through providers and seeking access to their medication by any means necessary. And that is horrible. That is going to directly result in the types of harms that these states are claiming that they want to prevent. But I do think it's important to just remember that we are a very resilient community and that we just need to try to be supporting, especially the most vulnerable among us, like especially the young and those who are very isolated in rural states. Just making sure that nobody's like forgotten and that we just keep going, even when things are devastating as much as they are right now.
And I will add, there's other recourse, and that is like advocate, right? Hold those public officials who pass those laws in the first place accountable, like stay, pay attention, get your communities involved, and then like fight back, introduce a new bill on behalf of those people who passed away in their name, saying like, we as a community are not going to allow another life loss over medically proven life-saving care. And, that avenue remains. And I'm so sorry. Yeah.
When you were delineating around the equal protection, some of the medical protocols that are allowed, but then it really paints the picture of how the transgender community is being singled out. Can you give those examples again, I think it's a good framework for people to understand that particular provision better.
You want me to do that? Yeah. So in the legal analysis is a little sort of pointy-headed and boring, but basically what it boils down to is that the same type of care is permitted in some contexts and banned in others. So a good example has come up in the abortion context. If you receive care for a miscarriage, it's the same drug protocol, same exact procedure that is performed in order to carry a mistake. Most people can understand that. That is perfectly legal, and actually all sorts of healthcare providers can provide that service. But if it's an abortion, the same exact procedure, same exact drugs, then it's illegal in certain regimes. So the courts have said, how can you claim that this is super risky or that the science doesn't support it in this context, but then in this other context, you can. So that's like the abortion context. In the gender affirming care context, the primary treatments that we're talking about are the prescriptions of hormones or puberty blockers for Tanner stage 2, so pubertal adolescents, right? And if you go into a Blue Mountain clinic and you have something called precocious puberty, meaning the early onset of puberty, they can prescribe you puberty blockers. That's fine. But under Senate Bill 99, if you went in and you said, I have a diagnosis of gender dysphoria, I would like to consult about receiving puberty blockers or hormones or both, they would be banned under SB 99. So the courts say, look, you can't justify, based on medical risk, banning a particular type of care in one context and allowing it in the other. And then, of course, what really highlights the irony, and that the court has really been interested in, is that in the same legislative session, they passed Senate Bill 422, House Bill or Senate Bill? House Bill 422, which expressly permits for the prescription of experimental drugs, experimental treatments, and even minors can provide an informed consent. So these are treatments and drugs that have no proven, effectiveness, and yet with one hand they giveth all of these rights to undertake experimental treatment, and on the other hand they take it away in the form of banning gender affirming care. Does that answer your question?
Thank you.
So I think one of the things that I really appreciated about today's hearing was hearing the layout of court decisions around abortion and how those parallel so well with a lot of the anti-trans legislation that we're seeing, especially around healthcare. And thinking about how much those things do parallel each other. One of the things that we've seen in Montana particularly is, given the state and the court's protection for reproductive health care, we've seen the state legislature get crafty around coming up with different ways to make abortion care either inaccessible or more difficult to get without completely going with an outright ban. And so what I'm wondering is, if we continue to see the state legislature follow that track of, instead of outright banning gender affirming care, but getting more crafty with how it's available or liability for healthcare providers, what's the potential, if there is any, legal recourse going forward?
So yes, I think that where the legislature has sort of been, snapped back by the courts, it's not the end of the story, right? They're going to try to come up with all sorts of new ways to, extend the statute of limitations, for example, on suing healthcare providers who provide gender affirming care, or, doing things like in the abortion context, they're trying to regulate the size of abortion offices, including like the hallway width and like stuff like that just makes it more onerous, such that providers aren't going to want to be in Montana. And I think that those are all probably, or potentially the next wave of anti-trans legislation targeting healthcare providers. The response that I would have is that, if you were listening, the last thing I read was a quote from in the courtroom today was a quote from the Armstrong case that talked about the ways that the Constitution is equipped to handle the ever evolving, attempts by the politically powerful to target the politically unpopular. And I think that we need to I believe that our Constitution has that inherent flexibility. And as long as there are badass attorneys like Malita to like vindicate those constitutional rights, I'm hopeful that we've got a backstop, even no matter how creative the legislature decides that it wants to be.
Yeah, I think that's absolutely right. And I'm just thinking the only other no, the only thing I would add is just I think we're probably I feel like we're gonna be reaching a point now too where things are starting to it's like we're seeing things reemerge, like previous strategies from like our opponents. I don't know. I just feel like we have a lot that we can also learn from like among movements, right? Like especially right now, I think over these last 5 years, there's been so much that we as advocates for transgender people have learned from those who have advocated for reproductive justice or access to abortion, and those who advocate for like immigrant communities. Like there's going to need to be efforts to like develop strategy across the spectrum of advocacy movements. And with these new efforts from our opponents, it might be a great opportunity to sort of develop those strategies. Because really what we're seeing is efforts to pin us against each other and sort of separate and divide us from a sort of point of like scarcity. And we need to fight the urge to give into that and just like try to remain committed to elevating and supporting one another's movements as well, as we move into this dark future. No.
And I think with that, we can wrap it up. Maybe just, no, I'm really sorry. We can wrap it up, but with each of you can share just some final words of maybe hope and action that people can take to help build a bright future that is abundant and full of rights and protections.
Yeah, I think stay engaged. Don't fight the urge to withdraw. Stay connected to community, and stay hydrated. Exfoliate, stretch. Let your shoulders relax a little bit. And just take one day at a time. I mean, this is really, it's a marathon. It's not a sprint, unfortunately. And so I think we need to be thinking of ways of maintaining joy, maintaining, love and positivity in the midst of what we're experiencing at the moment.
Yeah, I mean, I would modify what you said about it being a marathon, not a sprint, just a little bit, because right now is a sprint, and I don't think that any of us should be. We should all be clear-eyed that for the foreseeable future, given the sort of multiple ways that the rights of marginalized individuals are being shrunk, both at the federal and state level, like we all need to push back, and it's going to take collective effort. And whereas like a year ago, we may not have been as worried about the federal side, more worried about the state side. And now everything is feeling like it's happening at once. And if you're an immigrant or brown skinned or if you're trans or if you're indigenous, like all of those identities are going to be collectively impacted in the near term. And so the good news, I think, is that ACLU is built for this moment. But it's going to take all of us to collectively rise up to protect those rights, because we're only as strong as the weakest link in the chain. And we've got a pretty strong chain right now.
Mhm.
And I will tell you the legal side. It's a sprint and it's a marathon at the same time. If we're working collectively, then we can lean into each other to sustain us, to get through the sprints and then take the time to take the breath, drink the water, pass the baton to the other stronger link, and then come back in. And so that is the way that we will get through all of this. Goodbye.
How about you?